All right, welcome everyone to today's DCI Roundtable. My name is Bo Hayden, and our mission at DCI is to develop and advance innovation-based dynamic competition theories, tools, and policy processes adjusted for the nature and pace of innovation in the 21st century for the benefit of society and the maintenance of an open, democratic, liberal order. Today's roundtable will focus on Doug Melamed's recent paper entitled Mergers Involving Nascent Competitors. The paper advances a framework for a narrow prohibition of such mergers based on Section 2 of the Sherman Act. More broadly, the roundtable will offer a forum to discuss the law and economics of the treatment of killer acquisitions in antitrust policy. Today's guest speaker, as I just mentioned, is Doug Melamed. He's currently the professor of practice of law at Stanford University and has an extensive antitrust experience, having worked as a senior vice president for the Intel Corporation, as a partner for Wilmer Hale, and as an assistant attorney general for the antitrust division of the Department of Justice. Our two discussants today are David Bosco, who's the professor of private law at Aix-Marseille University, and we have Allison Stanger, who's a professor of international politics and economics at Middlebury College, and she's also teaching at Vienna, Austria these days, and we have her students here. So welcome everyone from Vienna. So without further ado, Doug, the floor is yours.
Okay, well, thank you, Bowman. Thank you for giving me this opportunity to present the paper and get the feedback that I expect will be very interesting. And I want to express also a very minor and parochial pleasure at seeing that Middlebury College is represented in the discussion speaker. One of my daughters went to Middlebury and is a great fan of the institution.
Those are actually Middlebury students that are tuned in.
Well, okay, a good tradition of Middlebury students. Okay, yeah. So, and I apologize, as you can hear, I have a little cold, so hopefully I'll be able to be intelligible and without being too grating. So the paper is of course, mergers involving nascent competition. It's a topic that's on a lot of people's mind. It's been on people's minds for a few years. The FTC's case against challenging the acquisitions by Facebook of Instagram certainly is an example of that, although an odd one in some ways. But it's not a topic on which I was intending to write. It was one that a few years ago at a conference, actually co-sponsored by DOJ, I suggested that maybe we should be thinking in antitrust in general, but particularly in this context, of the so-called expected values of alternative paths, the conduct at issue in the but-for world, rather than just likelihoods. And I'll come back to I think it's the importance of that in a moment or two. But a couple of years ago, or maybe a year ago, whenever it was, more than a year ago, I read a couple of blog posts by some prominent antitrust folks discussing the issue that were very conservative, and I thought were wrong in the law. So I wrote a responsive blog post principally on the legal issues, and it was well received by people who were on the left on this issue. And then I was asked by the folks at Equitable Markets to expand this a little bit into what would become a book chapter for a book of theirs that I believe is due out soon, but hasn't yet come out. So as I got into writing it, I decided that instead of just focusing on the legal issues or one or two of the policy issues, and I would try to provide a discussion of all of the major issues raised by this issue of a big firm acquiring a little potential and nascent competitor. While this isn't cutting edge economics, I think it's the only paper, I haven't seen any, that really tries to discuss all of the big questions that have been raised in this area. So that's what I'm going to talk about. So let me share my screen if I can. Let's see if this works. Okay. Mergers involving nascent competition. And by the way, I refer to it as nascent competition rather than nascent acquisitions or nascent competitors, because I think it encompasses both small existing competitors and smaller firms that are just potential competitors. Okay, so what's the problem I'm talking about? The focus of the paper is on acquisitions that allegedly nip in the bud a competitive threat to a powerful incumbent. the premise would be that you have an acquiring firm with substantial market power that appears likely to endure, at least in the absence of the independent development of the acquired firm. And you have an acquired firm which, if not acquired, has potential for substantial growth and development, which, if realized, could materially undermine the market power of the acquiring firm. And this includes so-called killer acquisitions that have been written about, as you know, in the pharma area, where an incumbent buys a nascent competitor to shut it down. But it's not limited to that. It could be, for example, Facebook, Instagram. It could be taking a nascent competitor that had a realistic chance of becoming the new paradigm, the next big thing or whatever, and operating it not as a rival unconstrained by an intention of protecting the revenues of the incumbent, but rather as a complement to the incumbent, and thus having it develop in a much less valuable way for society. And the potential for undermining competition could be as a direct competitor, or as in the Microsoft case with the Netscape browser, it could be by developing into an important complement or input into someone else's competitive challenge to the incumbent. I am not addressing in this paper issues raised when a dominant firm buys a startup as a means to enter a new or adjacent market, within mergers, for example. That raises very different issues. And of course, some of the people on the left oppose those mergers, not for economic reasons, but for what I would call populist reasons. They don't want the platforms to get too big. And I'm not interested in that issue. Not that it's a trivial issue, but it's not what I'm talking about. I'm focusing on antitrust. Okay, so you have an acquisition, big firm A buys little firm B. The legal bases, I'm focusing on US law for intervention, are two. The obvious one is Section 7 of the Clayton Act, which applies generally to all acquisitions of assets or entities, and it prohibits mergers where the effect may be to substantially lessen competition or tend to create a monopoly. Section 2 of the Sherman Act is also available. There's no question it applies to mergers, and it prohibits acquisitions that create or maintain monopoly power. Section 7 on its face would seem to be the natural home. It's the merger statute, or it's the statute specifically focused on mergers, and the language is quite broad. But in fact, the cases over the last several decades have suggested it's not entirely clear, but there's certainly a lot of law and commentary suggesting that a merger can violate Section 7 only if it is found that harm would be more likely than not to result from the merger. And I think that would probably put nascent acquisitions pretty much in a safe harbor, because a nascent acquisition, by definition, you're dealing with a firm whose maturity has not yet been realized, whose potential is very uncertain, in a market perhaps that is not yet fully matured. And so it's very hard to say with confidence, oh, harm is more likely than not as a result of this nipping in the bud of a potential competitive threat. So I think the proper approach conceptually would be an expected value approach. I think we would all agree that makes more sense in general in assessing probably any problem, but any kind of a forward-looking antitrust problem like a merger. Because it enables you to take into account the magnitude of harms and benefits, as well as the likelihood. And so potentially, it is a mechanism for thinking about a nascent acquisition where you would say, well, the odds that Instagram, and I'm just using that just for rhetorical purposes, that Instagram would be a major paradigm shift or really shake things up in social networking and really bring competition to Facebook of a type that it hasn't faced so far, the odds may be fairly small, but if it happens, that's really a big benefit. And the benefit from the economies of having Facebook combined with Instagram, while perhaps real, there may be real complementarities there, might, again, if the facts show this, be quite modest. And so you'd be talking about an unlikely big harm from the acquisition, nipping the competition in the bud, versus a more likely but much more modest harm. And one might think you should take the magnitudes as well as the likelihoods into account. Now, we can't do that quantitatively. We don't have the tools, probably never will have the tools. So what I'm imagining, again conceptually at this point, is a qualitative assessment. And so one might start by saying, well, the plaintiff has to show that the acquiring firm has substantial market power that is likely to persist if it's permitted to make this acquisition. And it has to show also that the acquired firm has a reasonable possibility of becoming a substantial competitor or a complement to a substantial competitor, and that it is the only or one of a very few such firms. And that last element I put in because it seems to me that if there are 10 firms equally likely to be the next big thing, and there are some efficiency losses in blocking the merger, one might say, let's have the efficiencies, the burden of hand. We still have nine potential competitors, potential path breakers out there, and therefore the importance of this to that unknown future, the importance of the acquired firm becomes much less. And I think it's probably appropriate to say, look, if both merging firms, I mean, if both of these elements are proven qualitatively to the satisfaction of the court, then the merging firms should have the burden to justify the merger. They can, of course, dispute these two propositions, but more likely, their burden would be to say, look, there are real efficiencies here. We're not just making a trivial acquisition. We see real benefits. And this is, sort of in the nature of the Philadelphia National Bank presumption. But as I said, I think under Section 7, you're swimming upstream against a lot of law in a very different context, of course, involving mature firms and mature markets, but nevertheless, a lot of law that suggests it's more likely than not standard. So I'm inclined to think that Section 2 is a better way to go, relying largely on the articulation of the standard for what do we mean by harm to competition. In the Section 2 monopoly maintenance case, Microsoft, of course, involved an existing desktop monopoly, and the theory was it was trying to undermine the Netscape Navigator browser in order to protect that monopoly. And the court said the plaintiff has proven sufficient harm to competition on this monopoly maintenance theory because it suffices to show anti-competitive conduct that is reasonably capable of making a significant contribution to maintaining the acquired firm's monopoly. And in that case, harm was found even though the demise of Netscape's, the harm to competition from that was dependent on a very uncertain, multi-step course of events and was very unlikely. Now, the conduct in Microsoft was found to have had no efficiency benefit. And so it was fairly easy for the court to say, well, the harm, however insignificant it might appear, outweighs the benefit. But the discussion of the standard for harm to competition in that case did not depend on that characterization of the conduct, that is to say, finding that the conduct had no efficiency benefits. And there are two reasons I like Section 2, actually, in addition to avoiding that language about more likely than not under Section 7. One is that there's an established rule of reason under Section 2 that is well suited, and courts have a lot of experience with it, in assessing both harm to competition and efficiency from allegedly anti-competitive conduct. And frankly, because it requires proving that the incumbent, the acquiring firm, is an existing monopoly, not just a big firm with some kind of market power, and therefore I think might limit the reach of the intervention I'm proposing a little more than would Section 7, if you can get around the more likely than not language. But when one imagines an expected value approach of the type I'm talking about, and by the way, let me say, these sort of two conceptual elements, the power of the acquiring firm and the potential of the acquired firm, I've stated them at a high level of generality. I would imagine that the courts, as they have done in the antitrust laws for decades, and in the agencies and merger guidelines, could, with some experience and further reflection, give more, make those elements more precisely articulated and stated, so they're not just mush. But expected value approach implies that some, maybe most of the mergers found to be unlawful will in fact be unlikely to harm competition. And And that obviously creates, I suppose, some issues and unease for a lot of observers about why is the government getting in here and making these sort of uncertain bets, as it were. I think of this as analogous to buying insurance. We think of preventing the next big thing, the new paradigm, as the harm, and we want to have some insurance against that harm, even though maybe that harm is less likely than not. We all buy fire insurance for our homes, even though chances are the building's not going to burn down. But I recognize that when you imagine going in this direction with government intervention, particularly in the culture of the U.S., which is a little more libertarian, I think, than perhaps across the pond, a lot of policy issues are raised, and I attempt in the paper to address some of the big ones to some extent, at least. So one of them is the error costs. As we all know, U.S. antitrust law generally tilts in favor of avoiding false positives, even at the expense of risking false negatives. The premise is that the market will correct false negatives. That premise has been criticized in general as placing too high a burden on plaintiffs and sheltering too much anti-competitive conduct. And in any event, it seems less necessary in merger enforcement, where almost all the enforcement is by the government agencies, than it is in general Sherman Act enforcement, where we really have this extraordinary, really decentralized enforcement, where almost anybody injured by allegedly anti-competitive conduct can bring suit before a generalist judge anywhere in the country. And in any event, whatever one might think of the tilt in favor of avoiding false positives in U.S. antitrust law in general, it seems to me the merits of tilting that way are quite inapplicable or inappropriate to these kinds of nascent acquisitions, because the premise of the argument is set forth by then Professor, now Judge Easterbrook, and others since then, is that the market will correct false negatives and do a better job than than will the legal system correcting a false positive. Well, the idea that the market's going to correct a false negative seems particularly inappropriate in a case where it is plausibly found that the most significant of very few, if any, threats to ameliorate a competition problem has been eliminated by the acquisition in question. Merger-specific efficiencies is another policy issue. How many do we want to sacrifice the efficiencies that one might imagine from these mergers? And I think this has to be taken seriously. I know there's a lot of writing in some circles in the last couple of years that downplay the importance of efficiencies. I'm not there yet. Maybe I spent too much time on the defense side. I think we have to take seriously because there are obvious potential complementarities, whether it's a complementary business or complementary inputs, intellectual property, talent, or whatever. But I don't think that possibility provides a basis to reject the proposed standard I'm proposing in the article. First of all, courts have experience, especially in Sherman Act cases, of evaluating efficiency defenses. Secondly, I think we have to be appropriately skeptical, because recent academic research suggests that merger efficiencies are often, generally, actually, much less than claimed or anticipated. Now, those studies, as I understand them, focused on revenue and cost synergies and didn't get into more intangibles like innovation and quality. But I don't see any reason to think that whatever bias there is in acquiring firms' assessment of likely efficiencies, whether it's an agency problem of management just trying to increase its position, or sort of a typical buyer's remorse story, I don't know if there's any particular reason to think that those biases wouldn't apply to other kinds of efficiencies as well. And I think many efficiencies, perhaps especially those in these nascent acquisitions, are not merger specific. People talk about acqui-hires. Well, you can hire the personnel. You don't have to buy the whole business. They talk about IP transfer. Well, in many, I'm not saying all instances, a non-exclusive license might suffice just as well. Okay, the law is, to be sure, unsettled where a court finds both harms and deficiencies. In fact, courts rarely find both. I have my speculation as to why, but if they don't find both, we don't have to worry about that. If we do find both, it's a tough problem. It's one antitrust has to deal with in any event. And one possible way of starting the inquiry in the merger acquisition is to look at the purchase price and see if it's more than seems reasonably related to expected efficiencies. It might support an inference of monopoly premium being paid. But I recognize for all sorts of fact-finding reasons, that's a difficult road to go down. Third, and this is one where I really hope the paper has made some kind of a contribution, because there's been a lot of talk about investment in startups being disincented by taking away this exit opportunity. A venture capital firm invests in a startup. It wants to get its money out in a few years. For lots of reasons, the IPO route is less attractive than it was many years ago. So exit by acquisition by a big firm is the number one exit path. And if we close that off or restrict it in an important way, the argument goes, we will reduce the very important investment in startups and in venture capital. There have been a lot of theories and a lot of arguments, but nobody, I think, has actually pulled together the learning and the thinking about this, and I tried to do that. I think this concern is inapplicable to the proposal I'm making. First of all, the proposal is narrowly targeted at a very small portion of nascent acquisitions, so just in a numbers game. Generally speaking, it's not going to change the likelihood of an exit path for most VC investments. And in particular, the proposal is narrowly focused on those for which there is the acquired firm has a viable alternative path. In other words, those for which the sale to the incumbent monopoly is the least likely to be essential for the venture capitalist to get his money out. Now, there have been some efforts empirically to show the impact of merger of acquisitions on investment in startups, and I think the safest conclusion one can draw is it's just very indeterminate. It's all over the lot, and no one has really tested hard to test, because there's no good natural experiment. The difference between a world in which entry barriers might be lowered a little bit by some antitrust intervention to prevent certain kinds of acquisitions versus a world in the absence of that kind of intervention. So I just think the data aren't yet there to support rejecting an otherwise sound approach to thinking of these nascent acquisitions. And if you go through the logic of what kinds of VC investments at the outset are likely to be deterred by the kind of proposal I'm suggesting, I think you find it's investments in firms intended to provoke an anti-competitive acquisition, and there's certainly no antitrust interest served in. It seems to me, or not much antitrust interest served in maintaining incentives for those kinds of investments. Okay, two other policy issues that I discussed. One is, what do you do on a series of acquisitions? We all know about the rhetoric. Oh my God, Google has bought a gazillion firms. Amazon has bought a million firms. They're just marching up and buying up all the people who stand in their way. I don't think that's what they're doing, by the way. I mean, I think that some of the acquisitions may well fall in that category. I can't believe all of them are, because I can't believe they're that vulnerable. They need hundreds of competitive threats they had to nip in the bud. I mean, if you believe that's a little hard to imagine, it's a serious problem. But there's another legal reason. The antitrust laws in the United States are explicitly focused on bad conduct. Sherman 1, Sherman 2, Clayton 7, they all explicitly apply to conduct, monopolizing, restraints of trade, and acquiring. And the law is quite clear that you have to find anti-competitive conduct. If Apple invents a touch screen and a nice camera and a series of pro-competitive product improvements, and as a result of that develops monopoly power in smartphones, you don't say, well, gee, the first two might have been okay, but they've actually had 4 product improvements, therefore it's illegal. That's not what the antitrust laws say, and I think the law is correct in that way. Even if the cumulative consequence of all of those aggressive and not anti-competitive acts is the creation of preservation of market power. Nevertheless, I think pattern of acquisitions could matter in these cases. First, the facts that they generate can shed light on the motives of the acquiring firm and the reliability of their efficiency claims. They may well change the market in ways that make subsequent acquisitions more or conceivably less likely to be unlawful. Obviously, if there are 3 potential new paradigms, and you buy 2 of them, buying the 3rd one, now you're nipping in the bud the only remaining one, and that could change things. And finally, if you imagine a bunch of acquisitions that have no efficiency benefits that can be proven or demonstrated, none at all, then maybe you could say, well, doing a lot of that, and thereby creating some harm to competition by reducing whatever small likelihood there was that those acquisitions could have shaken things up. Maybe that's illegal. Maybe the premise of the rule that says we have to find anti-competitive conduct is that if it's not anti-competitive, it must be pro-competitive. Maybe it doesn't apply in some of these situations. That's very speculative. Okay, final thing I looked at is the timing of legal intervention. This hasn't gotten a whole lot of attention, but I think it's worth commenting on, given, among other things, the fact that the government's case, the FTC case against Facebook was, what was it, 10 years after the acquisitions. And of course, the judge indicated a lot of skepticism about what's changed, why are you coming into court now? There's no question under the law that legal challenges after a merger is consummated are permitted under both Section 7 and Section 2, when there's case law both before and after the Hart-Scott-Rodino Act establishing that. And there's an obvious benefit because it helps a little bit assess the effects of the merger. But that's limited benefit. You learn a fair amount, I suppose, about what happened in the world with the acquisition, but you don't learn any more about the but-for world, what would have happened in the absence of the acquisition. It seems to me that post-closing challenges will be appropriate in some circumstances. New facts develop. The reason the importance of trying to establish an important legal precedent in Facebook, Instagram, I suppose, was motivated by that. I don't know. Maybe the agencies weren't notified and could not have acted before the closing. But in my view, and I know this won't make me some friends, too many friends in some of the circles in which I travel, I think such challenges should be very rare. Remedies are much more difficult, of course, after consummation because of changes in the market and in the acquired company. I think a cloud hanging over the acquiring firm about a possible future challenge will deter its efficient use of the acquired assets. Why invest in this company if I might lose it 2 years from now? And there's a risk of perverse incentives for inefficient conduct. I think scrambling the eggs, we saw that Facebook announced a few months before the complaint was filed that it's decided now, 10 years after the fact, to integrate WhatsApp and Instagram, in the back office operation, as it were, with Facebook. One can't help but wonder whether that was intended to make a divestiture remedy less feasible. And the alternative perverse incentive is to keep a lid on the acquired firm so that the court won't be able to be persuaded that it really would have been an important competitive threat. So that's the proposal. Basically, it's use expected value approach, bring it under Section 2, where you approve a monopoly, put the burden on the defendant to show efficiency sufficient to justify the acquisition, let the agencies and the courts develop more precision in exactly what these principles mean, bring cases only rarely, but don't continue to live in a legal world in which nascent acquisitions are almost in a safe harbor. And now I think it's time to hear from the discussants.
All right. Thanks a lot, Doug. Thanks for giving us great summary of your paper, and thanks for writing this paper. It's very timely. And I know we have a lot of people here that would like to ask you questions, but first we're going to start with David. David, are you ready?
Yes, thank you. Thank you, Bo. And thank you very much, Doug, for this incredible paper. I have to say that usually I'm quite skeptical about the tough enforcement of competition rules to killing acquisitions. But after reading your paper, I'm not that sure anymore. So thank you for that. And I note from your paper a very subtle advocacy in favor of the analysis of killer acquisitions, and a very interesting test. And also one major contribution of your paper, I think, is about the impact of an aggressive enforcement of competition rules to on investment in startups. Also, I note from your paper a strong advocacy in favor of application of Section 2 of the Sherman Act instead of merger control. And that rings a bell in my mind, because we have quite the same discussion now in Europe. And I wanted to share with you some thoughts about it, and on the way your paper could improve our knowledge and our experience in Europe about that. I don't really know if you're aware of that, but there are two major reforms in Europe currently. The first question is the application of the EU merger regulation to concentrations below the thresholds of control. Thanks to a new interpretation of the regulation, now the European Commission decides to assess the legality of acquisitions where the parties have a turnover below the threshold, and it's quite new. And the purpose of that is clearly to catch killer acquisitions. So we really need a test to assess the legality of that kind of concentration. And in your paper will be very useful for that. And the second point is about the application of Article 102 of the TFEU. And this provision is about abuse of a dominant position, which is quite the same than the monopolization provision in the Sherman Act. And we are discussing these days the opportunity to apply Article 102 to killer acquisitions, where the regulation doesn't apply to mergers. Is it possible to apply Article 102 instead? And that's something that we are discussing, in the Advocate General just delivered its opinion on that and said that it was possible to apply Article 102. So once again, your paper is going to be very useful in Europe. Because your idea is that it's better to apply Section 2 instead of the Clayton Act, and which is very interesting for us. So your article is very timely also in Europe. I have a few questions about your paper now. First, about the scope of your definition of a nascent competitor. I understand that you do not want to address the problem of a monopolist that's going to extend its monopoly on adjacent markets. In Europe, we have a lot of cases about that kind of situation. And I have in mind one case, which is Grail and Illumina merger, where Illumina is a big one, and decides to acquire a small competitor, which is Grail. And Grail is one competitor among others in the technology that has to do with the health sector. So the mere fact to acquire Grail is a way to create synergies. But it is clear that Grail is not going to become the next big pharma if the concentration doesn't occur. So my question was, even if I understood that your paper is not exactly on that point, but would you have some elements, some food for thoughts for us on that point? Do you think that we might adapt the test you are proposing to address that kind of problem where the small startup is not going to become a competitor for the acquiring firm? So does it work? Is it possible to apply your test? And if it doesn't apply, what could we do instead? I don't know if it's an easy question to answer, but because our paper is not exactly on that, but we have a lot of cases. And you mentioned also the Meta and Unlimited case, which is quite the same problem. So I just wanted to know if you have thoughts on that point. My second question would be on the problems of ex-ante efficiencies you are addressing in your paper. And once again, I think the major contribution of your paper might be on that point, the fact that to understand the impact of an aggressive enforcement of competition rules, the impact on investment in startups. And once again, I think your arguments are very, very interesting for scholars. I have another question that has to do with the same problem. My concern is also that even if these tests and this application of competition rules, antitrust rules to only a small number of concentrations, even if we all know that only a few concentrations, transactions will be affected by the application of antitrust rules. Don't you think that that kind of attitude against mergers will have an impact on other mergers? Because the practitioners will have to assess the legality of the merger or acquisition. And I just wonder whether it's not going to create a burden, a legal and administrative burden on all the mergers, even if only a few mergers are going to be concerned by that kind of enforcement. So my point here is to say that law is bigger than what we see in courts. And the problem is that the parties will have to comply with antitrust rules, even if they are not concerned by a procedure. So don't you think that there is also a problem of ex-ante consideration of the application of antitrust rules to mergers that do not raise competition problems anyway? And maybe my last point will be on, maybe it's something that has to do with Europe more than United States, but I wondered what would happen if we apply Article 102 on abuse of dominant position instead of merger control to that kind of killing acquisitions. And I have two concerns. The first one is the length of procedures. There is a part in your paper where you're talking about the timing of the application of antitrust, and I wondered whether we might have also a problem with the length of procedures in Europe. I think that's also the case in the United States. It takes a long time to have a solution. And the enforcement by competition agencies is quite long. Even if we have interim measures, we do not apply this tool a lot in Europe. It takes sometimes more than a year or two to have a solution. And meanwhile, the market is about to tip sometimes. So I wondered whether an ex post system is better than an ex ante system, because in an ex ante system, and merger control is one of that kind of systems, the market doesn't have the time to tip, right? So the length of procedures using Section 2 or Article 102 might be a problem to solve the questions you're addressing. In practice, the procedure are too long. And so even if we have a very good test, it might be too late to solve the market failures. That's the first point. And the second one is about the test itself. If we apply Article 102 in Europe to killing acquisitions, we will have to find a consistent way to apply Article 102 to these mergers with the case law we already have on Article 102 about abuse of dominant position. And I just wondered whether the rules we have and tests we have will be appropriate. I just wanted to share with you the actual state of the case law on Article 102. The Court of Justice says that we will have an abuse if the conduct of the firm would exclude an as efficient rival on the market. So I wondered whether the test you are proposing would be consistent or could be applied in this framework. Because we are talking here about potential competitors that would be potentially as efficient than the acquiring firm. So, well, to conclude, once again, I would like to say that your paper is clearly relevant even for European lawyers, because we have common concerns these days about the application of Section 2. We are discussing now of the application of Article 102 to killing acquisitions. So thank you very much once again.
Well, thank you so much for this really nuanced approach to a very important problem. I agree with David that the rule is and the test is very promising. And I learned a lot from your talk. It clarified some of the questions I had from the paper, so I'll spend less time on that. I just first would start off with two just remarks from hearing your talk and what they provoked in me. And I'm not a lawyer. I'm a political thinker, political economic thinker, I would call myself. And I would just say this, that the idea of how we would evaluate the counterfactuals in the Microsoft case with Netscape, that was a fascinating thought experiment for me. And this might interest my Middlebury students who are reading Brad Smith's book. One could argue that the counterfactual were that case not to have been successful is that we wouldn't be seeing the leadership we now have from Microsoft in AI safety and alignment. That's very much a result, Brad Smith tells us, of him learning the hard way, that if we don't think preemptively about the response of the public and perceptions and reputations, this will be bad for business. So that's a pretty big gift. And I wonder whether we need to take that into more consideration. The second thought I had was, in listening to your talk, was that we're talking about all kinds of markets, but we haven't talked about the market for data. And I wonder if we can safely neglect that market any longer in antitrust considerations, because when you spoke of Facebook acquiring Instagram, you know, there are a variety of ways we could say that's something having to do with nascent competition, but we could also say that this is Facebook's attempt to monopolize the market for data. So I wonder if you had anything to say about that. I liked your approach to the evaluations of mergers under nascent competition. That is the expected value approach. Again, speaking for my students who are listening, you might see some very interesting parallels to Will McCaskill's long-termism in this approach. We could have a separate conversation about that. But as I see it, and I just want to make sure that I'm understanding you correctly, what you're arguing is that we can weigh the probability of a false negative against the probability of false positive and the consequences thereof for both while at the same time considering potential gains and efficiencies that benefit consumers. I'm reducing this to a verbal equation. I hope I haven't distorted your argument. I wonder if that I've captured it correctly. And if I have, isn't this in essence a long tail problem in that we're trying to preempt a high risk, low probability event? And that gets a little tricky in forecasting its likelihood. You are arguing that we need to use a qualitative assessment, but we might say that for human beings, we have a whole raft of techniques for reasoning with incomplete information. But for the kind of AI techniques that are currently popular in prediction, and which rely more on big data than on reasoning, this is a very serious issue. So if big data isn't going to solve the problem, how do we know which mergers to challenge and which to allow? In other words, what analytics can we use to actually make the determination where it's worth pressing a case? Or to put it another way, I'm thinking to myself how you might answer that. You might say, well, you should err on the side of missing one merger involving nascent competition, or as you put it, I don't think you put it exactly this way, but I would put it this way: avoid false positives and risk false negatives. Again, I'm wondering if this really captures what you're arguing. So I wanted to have you comment on that. I liked your critique of the Wu-Hemphill position on nascent competitors in your paper. You didn't mention it in your talk, but I thought that was interesting. And as I thought about that, I began to think about, well, what other sorts of objections to this argument could be raised? And again, I know you stated at the beginning that you were excluding, certain highly charged political cases. I want to put those back on the table just for the sake of argument and raise two potential objections to your argument, simply because I think reviewing them could generate some very interesting discussion, even though they do move beyond the confines of your paper as you define them. So consider this an intentional provocation. So first would be, of course, the Lena Khan objection. You seem to agree with Lena that price setting is not the only measure of monopoly, but you steer clear of assessing the political ramifications of mergers involving nascent competition. Khan would argue, of course, that the spirit of antitrust law supports preventing the concentration of political power as well as economic power. So in her famous or infamous, depending on one's political perspective, Yale Law School Journal article, Khan cites Amazon's control of critical infrastructure for e-commerce as a potential source of political power, which incidentally they did use in a positive way during the pandemic, but that's an aside. Khan writes that, and I'll quote her here, the concentration of economic power also consolidates political power. This occurs through enabling a small minority to amass outsized wealth, which they could then use to influence government. So it follows from that great wealth leads to outsized political influence in the contemporary political system, and in addition, widening gaps between the haves and the have-nots of this world, so growing inequality. And this is not only the case with Amazon, of course, which was Khan's focus, but we can also see the outsized political influence in the newspapers today, looking at Elon Musk's acquisition of Twitter. He's wielding enormous power in the run-up to the midterm elections in the United States. So, I can't help but ask you, how would your argument respond to Khan's? And the second potential objection to your argument would be what I would call the Zephyr Teachout objection. She's written a book recently entitled Break 'em Up. And it's a polemic, but it's also very well argued. It's worth reading. She argues that price gouging is not the only measure of monopoly, much like Khan argues. Here's how she puts it. She says, monopoly is a rival form of government burrowing its way into democratic government. So we must always strike the root of its power and not leave anti-monopolism for later. You may think that stopping mergers and breaking up companies are the only anti-monopoly tools. That's too narrow. Anti-monopolism is a broad philosophy standing in opposition to unaccountable private power. Campaign finance laws, predatory pricing law, public utility regulation, laws that make co-ops easier to organize, and the right to sue big companies all count as ways to break up power. Monopoly, she says, is tyranny, and no democracy can survive for long once a few corporations have amassed governmental power in such a massive form and scale. And she goes way beyond the technology companies to look at big pharma, big agriculture, and so forth. Your paper does talk about the potentially dangerous unintended consequences of ex post antitrust action. But teach out wouldn't buy this. So how would your argument respond to teach outs? Are there some firms, that is, whose currently outsized political power and influence are actually antitrust problems, regardless of their stance vis-a-vis nascent competition, which is what teach out would assert? So in short, stepping back for a moment to survey the big picture, your legal position, I think, is clear, but your larger political commitments are less so. But I think it's fair to say that politics are very much a part of the antitrust landscape, especially in the decision of what charges to mount and against whom. So we are citizens as well as consumers, and when push comes to shove in a democracy, citizenship arguably should take precedence. So where do you stand as a citizen and not a lawyer on antitrust issues? For the purposes of full transparency, I've argued elsewhere that what we want as consumers may not be what we need as citizens. And since open societies and free markets optimize for innovation, that's a good thing. We need to sometimes choose our obligations as citizens over our desires as consumers, if we're going to think about the long-term sustainability of open markets and democracy itself. So I'm wondering to what extent you would agree or disagree with that proposition. So those are just a few things thrown out there, hopefully to get a good discussion going. And again, thank you for a great paper. I really enjoyed reading it.
Great. Well, thank you, Allison. Doug, did you start out by trying to delimitate what you were going to talk about, but then you got pulled into Europe and politics? So it's you tried hard, Doug, but I'm curious now to see what you have to say. Please.
Somehow, the ivory tower just can't stay pure, can it? Bowman, thank you guys, both David and Allison. Terrific comments, terrific questions. I have a million things to say. Bowman, how much time do you want to give me to respond to them so I don't get run over?
You have like is 10 minutes, okay? And then we can also
Yeah,
continue on in the rest of the roundtable, but maybe.
Sure, that's fine. Thank you. Okay, let me start with the last point because I want to kind of basically take it off the table. It will be seen. I look at the U.S. antitrust agencies now, the Antitrust Division and the Federal Trade Commission, and from what I can see so far, things could change. They're worlds apart, even though they're both headed by very aggressive and very smart folks. The Antitrust Division is trying very hard. And I've talked to Jonathan, and I know some of those folks, trying very hard to address the simple reality that their job is to enforce a law, and they have to figure out a way to bring the cases they want to bring consistent with the law. And that's a task we faced in the Microsoft case, of course, 20 years ago. How do you nudge the law a little bit where it's not so clear, but do it in a way that the courts might accept? And Jonathan has brought in, Susan Athey is the chief economist, doesn't get any better than that. And that's a terrific enterprise. I don't agree with everything he said or done, but he's doing the right thing conceptually. My view, Lena and the FTC are just way off base. Because I don't see any effort by them to come to grips with the simple reality that unless they get new legislation passed, they got to deal with antitrust laws. And they got to deal with the case law although it evolves over time in a common law-like process. They don't even have a chief economist. They haven't brought on the kind of litigators you need to identify and develop and win important cases to nudge the law, because I think they are caught up in their ideology about political economy. Now, I think we have in society a hugely serious problem now. We're in a Gilded Age, and maybe in some ways less easily correctable by the political process than the first Gilded Age was at the end of the 19th century because of what's happened to the political rules of the game. And it's a very serious problem, and it should be addressed. Antitrust is not the appropriate vehicle for addressing it. It is about bad conduct. It is not about bigness. It is not about power. It is not about monopoly. It is not about political power. It is about anti-competitive conduct. So we need a new set of laws, and I don't profess to be an expert in the field, but except to say it's a hugely important problem. It's just not one I wrote about. Okay, let me go back to some of the other terrific questions. David asked about monopoly extension. Big guy, Amazon buys a chocolate chip company to get in the chocolate chip business. Look, there's two ways you can look at that. One, you can look at it in an antitrust sense and say, well, what's the harm? If there's a theory of harm to the the nip in the bud theory about protecting the incumbent monopoly, I talked about that. If we're talking about a competition in the adjacent market, then I think you have to think of in that example, Amazon as a potential entrant into the chocolate chip cookie business. And we have some well-developed tools for analyzing potential competition cases there too. I would probably say the law should back off from the more likely than not standard and think a little bit more in expected value standards. But it should be confined to the economic issues in which antitrust is focused. And by the way, I completely agree that price gouging is not the only concern. Oughtn't to be and is not. It's a myth. It's a straw man, frankly. I think that the new Brandeisians have put up about antitrust is all about price. Not true, and never has been true. But here's the problem. Often the complaint about these market extension acquisitions is that, they will give the incumbent, the acquiring firm such efficiencies that they will be able to take over that market. They will gain data, they will gain expertise. They know a lot about chocolate chips because they've been selling chocolate chips for third-party vendors for 10 years. And oh my God, they're going to be the best chocolate chip company in the world. And this is a terrible thing. That's not an antitrust problem, because that's an efficiency, wealth creating story. It may be a political economy problem, not my problem right now. Okay. The burden on all mergers, not knowing what the future holds with this cloud, even though it's a low likelihood cloud as opposed to a complete prohibition on acquisitions of little guys. There will be some burden, but let's think about how that plays out. It plays out when the firm says when Facebook says to the lawyer, I think I want to buy Instagram, and the lawyer says, okay, let's focus on your efficiency story. You really have a good one here. What's going on here? Let's think about this ex ante in terms of how is this merger really going to enable us to build a better mousetrap? It's a little bit like, Allison, you referred to the Brad Smith story about the lesson they've learned about how they got to be ahead of the market, not just protecting their base. I looked at it as the Intel story when I was there, which is a Christensen effect story of being complacent and not thinking ahead. So I'm not sure that burden, as David put it, while it will impose some transaction cost, is on the whole a bad thing. I think what it does perhaps is nudge the incentives of the firms to be more sharply aligned with the public interest. Ex post versus ex ante, yes, there are real costs in trying to do an ex ante. The issue there is, are we more worried about preserving the competition, which may be irretrievably lost if we bring an ex post case, in which case maybe all we're going to establish is a precedent, which I think is all Microsoft ultimately established. Or are we more concerned about losing the efficiencies, which might happen if we bring the case ex ante and block a merger that it might turn out would have been harmless. And I because of some skepticism about mergers and about the efficiencies and about the magnitudes of them, I guess I'd be willing to run that risk, but I think it's a fair question. Article 102, yes, it said we're concerned only about preserving the as efficient competitor. That was the Intel case, by the way. That was in an exclusion story where the competitor did not agree to stop competing, but was undermined. And that, I think, is an interesting, conservative, but defensible test in an exclusion case. The nascent acquisition story is really a collusion case, because the real premise, to oversimplify, it wouldn't always be true, but to oversimplify, the premise is Facebook buys Instagram and pays a monopoly premium because what it's really buying, at least in part, is insulation of its incumbent monopoly. And that's a collusion story. I don't think that most efficient competitor standard really does or ought to have a whole lot to do with that. All right, Allison, you asked the question of the market for data. Hugely important. Data is hugely important, but conceptually, it's an input into these businesses. And some of the aggrandizement there is, I believe, an efficiency. You know, the idea that some of the proposed legislation addresses is that Amazon can't take what it learns about the retail market from selling 1 million third parties products, can't take it and use it to inform its understanding of those markets and maybe competing in them and building a better mousetrap. That's an efficiency. Now, there may be issues of did they use market power to coerce access to that data and the terms of trade and dealing with the vendors? That's a separate issue. But the aggregation of data, generally speaking, is itself an efficiency, and I'm not, from an antitrust point of view, troubled by that. You know, big caveat, political economy, different issue. Long tail event, yeah, definitely we're talking about long tail event. And the issue is, how are we willing to run the risk of the the black swan event? And again, a lot of that depends on how much weight you're inclined to give to the efficiencies. And I'm not inclined to deem them to be so great as to say, well, we ought to run that risk all the time. I'm inclined to say, if you have a situation where that long tail risk appears to be a little less long than the random case, maybe it's time for the parties to really demonstrate that there's a good reason why we should allow this merger. How do we know? Beats me. You know, I mean, I'm this is kind of an invitation to the economists and the agencies when they write guidelines to think very hard about this and begin to advance the ball. And over time, I think we'll learn a lot. I don't really have any crystal ball about how we do that. But I think if we ask the right question, and I think this kind of expected value framing and maybe shifting the burden, because efficiencies are best addressed by the parties, not by the plaintiff. Maybe that's conceptually the right way to do it, and trust the institutions, to learn as appropriate as they're trying to implement that standard. I think that covers all the questions that you guys asked, all of which were terrific, and all of which warrant a much longer answer than I was able to give in the 2 minutes I have.
I'd just like to thank Doug and Allison and David for discussing this topic. We're going to end the public part of it here. So thanks again to everyone. And now we'll move over to the roundtable.